Yes.
I beg the motion item number 23. For restaurant number 2 and 3. Better come after 3 weeks now.
Okay. You've taken consent?
So I appearing for restaurant number 1. And restaurant number 2 and 3, we have asked me to.
You have informed the other side? You have informed the other side?
No, I'm not for restaurant.
Have you informed the other side?
Yes, I think it's on leave of absence.
Okay.
Yeah, I don't think.
Both sides are represented on the prayer made by the Honorable Chief. The matter stands adjourned today, just after 2 weeks.
3 weeks, question.
3 weeks.
Should there's an interim.
Okay, interim order passed earlier stands extended till the next date of listing.
May I please, Your Lordship, I may be allowed to mention from the hearing list, item 31 and 32, Your Lordship. This matter may kindly be listed after a week, Your Lordship. I have personal difficulty.
Next week, Lordship. Next week.
Okay, 31, 32. Both sides are represented on the prayer made by the land commander. Okay, list after a week. Okay,
Lordship, that may kindly be fixed 16 of September.
16th.
Yes, Lordship.
Lordship.
Much obliged, Lordship.
Yes, Lordship. Lordship, I make the mention item 30. Make a mention on behalf of Mr. Ankit Todi, Lordship. Lordship, if the matter can come up on Friday for hearing, Lordship, there's some difficulties today.
Friday will be some difficulty. Thursday we can accommodate. Because I'll have to leave early.
Lordship. Lordship, then in that case, Lordship, there's a little type of tied up this month, so it can come after the puja, Lordship.
After puja is a long time. It's
After 3 weeks.
say 3 weeks, then you say. Both sides are represented on the prayer made by land council for the petitioner. List after 3 weeks.
Lordship, in the interim, kindly we can go through, Lordship.
Interim order passed earlier stands extended to the next date of listing.
I would like.
May I please, Lordship? Lordship, may I mention item number 14? Lordship, here I'm for the private respondent and I'm here to file my affidavit. Kindly allow me some more time to file my affidavit.
Is a 24 matter?
Lordship,
Why are you taking so much of time?
Lordship, I'm actually waiting for some documents from my client side.
Okay. Both all sides are represented. One last opportunity is granted to the private respondent to file affidavit in opposition, failing which the matter would be heard on the basis of materials available on record. List after 2 weeks.
Lordship. Lordship.
And this Lordship, I beg the mention hearing item today. Item today, hearing item.
Item 20,
India.
28.
Lordship, let the matter be kindly come out after 2 weeks, Lordship.
Okay. You're for the petitioner,
Yes, Lord.
okay. After 2 weeks.
My pleasure, Lordship. Lordship, I beg to mention item number 15. Lordship, I'll be filing my affidavit during the first of the day, Lordship.
Yes, what has happened?
Lordship, I'll be filing my affidavit during the course of the day, Lordship.
Okay. You're from?
I'm from the state, Lordship.
Okay, what says you represented? The learned government advocate submits that the affidavit in opposition shall be filed in course of the day. So matter stands adjourned today. List after a week.
Lordship, I also like to beg to mention item number 16. On behalf of M. Longomar. Lordship, kindly grant 3 weeks time to file affidavit.
Is it 24 matter? What is the issue here?
Lordship, I'm on behalf of my colleagues, Lordship.
It's okay. Let us see item 16. There are several files here, that's why.
Lordship, I'm for the private respondent. We have to file my account affidavit. The petitioners are seeking appointment on land ownership basis.
Okay, job against planned. Okay, we give you 2 weeks time as the last chance.
Lordship.
Both sides are, all sides are represented. One last opportunity is granted to the respondents to file affidavit in opposition in the matter. Failing which the matter would be heard on the basis of materials available on record. List after 2 weeks.
Lordship, item number 18. On behalf of AIB,
Yes,
kindly grant 3 weeks time to file affidavit.
okay, both sides are represented. 3 weeks time granted to the learned government advocate. You're for government.
Lordship.
We'll get to file affidavit in opposition in the matter. Okay,
Lordship, similar prayer with item number 19.
okay, same order, 19.
Lordship, item number 24. On behalf of Tiba, he's yet to receive instructions, so if 3 weeks time, we kindly grant it to me, Lordship.
24, 3 weeks.
Members, my lord. My lord, here, the petitioner has wrongly implicated the 2 respondents. So,
Which item?
item 24. Item 24.
They have wrongly implicated.
Wrongly implicated the respondent 4 and 5. That is, they had the district head Dobashi and the head Dobashi. So, if this honorable court may be pleased to strike up their Mr. 4 and 5, Lordship.
Just here.
Item 24. Since they are court,
But for striking out, you'll have to file an application. Under the new directions, the notifications issued,
Lordship,
if they have, if the cost title is to be amended at your instance, that you'll have to file an interlocutory application.
Lordship, I mean, we are allowed to file a appropriate application.
Okay.
Lordship, that's an interim. Can let him continue, Lordship.
Just add there, the learned counsel for the petitioner submits that the petitioner has wrongly implicated respondent numbers
4 and 5.
4 and 5, and therefore he craves leave, the SSC craves leave to file an interlocutory application for deletion of their names. So such an application may be filed prior to the next date of listing. Next interim order partial list stands extended till the next date of listing. List after 2 weeks.
Lordship. I'll go back.
Lordship, I also like to beg to mention item number 17.
Item
17.
17.
Lordship. Lordship, kindly grant me 2 weeks time to file affidavit in reply, Lordship.
Okay, both sides are represented, to which time is granted to the counsel for the General Government Advocate to file affidavit in the matter. Yes.
Lordship, from the hearing list, item number 27. Lordship, on behalf of AIME, if this matter will come up after 2 weeks. I've
No,
taken the
this,
consent for
we'll have some problem, just a moment, because it's a fixed matter. This matter was,
Lordship, share some personal difficulties.
let us see. All throughout this matter is being adjourned at the prayer of the this matter was, has been adjourned on several occasions on the prayer made by the counsel for the parties. You're making prayer on whose behalf?
On behalf of AIME.
He's representing whom?
For the state, Lordship.
Okay. Once again, the prayer for adjournment is made on behalf of the government advocate. So the prayer is reluctantly allowed. So no adjournment shall be granted to any of the parties on the next date of listing. List on 23 September 2025. No adjournment on that day.
I pledge, Lordship.
May I please, Lordship. Lordship, I beg to mention hearing item 26, Lordship.
It's
Lordship,
2021 matter.
Lordship, however, the arguing concern has some personal difficulty. I am representing for respondent number 4. So Lordship may adjourn this matter for today.
No, let us see, let it be called, it's a 2021 matter.
Lordship,
Let it be called, renew your prayer when the matter is listed. I mean, the matter is called.
Lordship. Much obliged.
For admission, item numbers 1 to 13.
In this repetition, you are claiming that your natural justice was violated. How do you say so?
Altogether, there are 13 writ petitions. All are onlookers. They are agreed by removal from service.
Yes.
And the basic issue involved in this is there has been a serious irregularities in conducting the inquiry.
But is the
Lordship
degree of Mewar University valid? Is the degree that elementary education degree from Mewar University, is it valid?
That is the issue, Lordship. For that inquiry has been conducted, we are questioning the inquiry that there is violation of principles of natural justice. The incriminating documents should be furnished even to the delinquent and accused, but then that has not been furnished. And then they were, although in the order is categorically mentioned that if the petitioner is interested to hear in person, then that should be intimated. And accordingly, we have intimated to the authorities that I may be heard in person. What they have done is, since there are so many persons involved in the case, they have made the questionnaire, prepared questions, yes or no. Some sort of that format was prepared, and then you don't have to say anything, you just say yes or no. Just fill up the form, and then you say that. On the basis of that, they have arrived to the conclusion.
Come to page 32.
And no.
Come to page 32.
Yes.
See, annexure 3. After this, what is required?
List of documents by which the article of charge is framed against Srimati so-and-so proposed to be sustained. Number 1, letter from the competent authority of the Mewar University registered certifying that the diploma in elementary education, DLIT, certificate submitted by Srimati so-and-so is fake, not genuine. So that is one of the annexures.
Yes.
And then list of witnesses, only one person has been shown. Now, the purpose of conducting the inquiry.
Let's see page 34, your reply.
Yes. Type copy is at page 35. That is more clear. Also.
No, page 34, that, okay.
Yes,
It's a
34.
type copy.
Type copy
Okay,
is
okay.
at page 35.
Okay, okay.
That is more clear.
Okay. 3. 35, 3.
Yes. As directed, I am pleased to hereby submit my documents purportedly found to be fake as alleged. As also mentioned in annexure 3, to produce a certificate from the Mewar University, I could not produce as I was misguided and misled and unable to trace the persons who misguided me. Whatever may be the case, Lordship, when you are conducting an inquiry, Lordship is well aware that roll up Audi Aldaram Badam should be followed. At least I deserve to be afforded a reasonable opportunity to defend myself, more particularly when a penalty of this nature is being imposed, where the life of a person will be ruined by such a consequences. And earlier occasion, Lordship, there were 14 cases altogether. One of the cases have been taken up by this honorable court.
I've seen that page 50 something.
That is interim order, Lords. That is at page 53, starting from 48.
That was stayed.
Yes, that is interim. But thereafter, the final order was passed. I will also place a copy of the order to your Lordship. And this case will cover the other remaining cases also. And the operative portion, Lordship will find at page 29 and 28 and 29. But I think we should read the entire attachment also, since there may be conflicting orders on the
No, you
same
see,
issue,
once you read this affidavit of Mewar University,
Lordship.
nothing remains to be.
That is why, Lordship,
Uh,
in order to avoid any conflicting judgment, it will be relevant to refer this judgment also. This was decided on the ground of violation of principles of natural justice. By avoiding the irrelevant paragraphs, I may be allowed to read, Lordship, the judgment which was passed.
Against this order, any appeal has been filed? No.
No,
No, Your Lordship. However, Your Lordship, the facts there and the facts in the present writ petitions are different. I will satisfy my lord on that.
Okay, because the finding is similar that the hearing, there was a violation of principles of natural justice.
Yes, yes. So that part, Your Lordship, that part I will satisfy my lord.
Okay.
the only difference between this case and the other cases are the name of the person has been shown another person against the inquiry conducted by me. That is the only difference. Otherwise, all are same. Notice issued by the authority is same. Inquiry, the manner of conducting inquiry is same. Everything is same. And the order dated are also same. All same. And format which was furnished to the petitioner in this particular case and the remaining cases are also same. There is no difference. The only difference is instead of showing the name of the petitioner, Autula, in one of the documents, the name of Alila Imsom, another person's name, who is also one of the petitioners here, has been shown. That is the only difference. Otherwise, is essence, there is no difference between this case and the remaining 13 cases, Lordship. So if my learned friend has got more document to show, to distinguish between this case and the other cases, let him show. But so far as my
No,
knowledge
you
goes,
complete your part. Then he'll
so far
definitely
as my
show.
knowledge goes, that is the only difference.
Hmm.
May I read the judgment, Lordship? It is the judgment and order dated 13/10/2023. May I read from paragraph 2? The writ petition under
page,
Article
Page,
226 of the
page. This judgment,
Yes, Lordship.
this judgment.
Yes.
Huh.
May I read from the beginning?
No, don't read that. You just tell us.
So the substance is, operative portion is at page 28 and 29, page 20 of the order.
Because here you took a plea that he was a victim of fraud.
Almost same
Huh.
in all the cases. Because we do not know which one is genuine or which one is not genuine and which one is genuine. It was not possible for us at that point of time. On the basis of an advertisement, we appeared in the interview and then got selected and appointed. And subsequently, we were asked to obtain BA degree and DLIT degree. So we have furnished a certificate. Subsequently, we found that no, it appears to be not genuine. So inquiry should be conducted. An inquiry was conducted. Our grievance is that, okay, fine. If you want to conduct an inquiry, that is your prerogative, but it has to be conducted in accordance with law. That is what we have been insisting from day one, Lordship. And the similar case, Lordship, which I'm referring, let me read paragraph 28, that is operative portion 28 and 29.
Of this judgment.
Passed in WPC 112 of 2022.
Yes.
Srimati Ausana Poganar versus the state of Nagaland and others. Page 20 of that Desmond, paragraph 28 and 29.
You can also read paragraph 21 that appears to favor you.
Yes. 21 is also relevant. It also appears from the inquiry report that against the heading of the case of the disciplinary authority, nothing has been stated about the case of the disciplinary authority or regarding the evidence by which the said case is proposed to be proved. Rather, it is only mentioned therein that the charged government servant submitted her statement of defense on 14/3/2022, wherein she denied the article of charge. Therefore, it is not clear from the inquiry report of the Board of Inquiry as to whether the present petitioner was afforded an opportunity to cross-examine the departmental witnesses or to counter the departmental evidence. This is a solid point where we were not given that opportunity also. At least I should be afforded an opportunity to cross-examine the witnesses also. That was not done. Though it also appears that the present petitioner was asked to fill up the questionnaires by the Board of Inquiry. This is what exactly happened, submitting lordship. However, there is no mention or any discussion about the said questionnaire in the inquiry report. Further, a bare perusal of the inquiry report dated 7 April 2022, it's in respect of all said inquiry. It appears that the Board of Inquiry came to a conclusion that ICDL Dimapur does not fall under the category of institutions recognized by NCTE to function as a study center of B.Ed course offered by any university, and it was the responsibility of the candidates to ascertain the credentials of the institutions before taking admission and satisfying themselves that the institutions offering B.Ed courses fulfill the norms prescribed by NCTE. However, the Board of Inquiry nowhere made an observation that the present petitioner submitted B.Ed certificate knowing the same to be the fake certificate, and perusal of the observations made by the Board of Inquiry at point number 6 and 7 under the heading Assessment of Evidence of the Inquiry Report, it appears that it is ICDL Dimapur which was unauthorized to function as a study center, and it appears that the petitioner was victimized as because she undertook the B.Ed course in an unauthorized study center. The plea of the petitioner that her B.Ed certificate was not fake was not considered by the Board of Inquiry. The Board of Inquiry failed to take into consideration the fact that to submit a fake certificate knowing it to be so is a different thing from the fact that a certificate which was submitted thinking it to be genuine, but which was later on found to be fake. 24. It's only ground for.
Here, I have a question to you. You see, I know that I am a commerce graduate. Now, in order to impress you all, I say that I am an engineering graduate, I am this, I am that, I have this degree, I have that degree. Just for fun, I am just telling the bar here that this is the degree which I have. Now, in order to have engineering degree, I must study in an engineering college.
Correct.
So the finding of the learned single judge is that he is a victim of fraud. Now, how can that be? I make a I claim to have an engineering degree. Can I say that I am a victim of fraud?
No, I would like to differ a little bit in that. Lordship is possessing commerce graduate. And Lordship is saying that I'm an engineering graduate. That is not the case here. Yes, I'm a commerce graduate, but the authority from where I obtained the commerce certificate, I was not knowing that it was a fake university, but ultimately it was found to be fake. That is the issue here in this case. I'm saying this is my B.Ed certificate, but I do not know whether the university was genuine or not. But thinking it to be a genuine one, I studied and I obtained.
No, after
And I
this,
submitted.
what do you call this lift engineering case, where there's a categorical finding, then there are UGC guidelines, which says that it is not. In a very recent case also which we heard, there also the UGC provided all the documents saying that the off-campus is not even permitted. So these people studied where? They don't say that anywhere. I did not find it anywhere. Of course, I did not read it very thoroughly, but the place where they had their education, this is something I missed out.
Actually, in case of the petitioner, even in the advertisement, this is not one of the basic educational qualification. It is an open advertisement, and in response to the advertisement, I got selected. And only after the selection, I was asked to obtain paid degree. So I joined and then finished up. Subsequently, it was found that this is not genuine. So in connection with that, the inquiry was conducted. But in the course of inquiry, it was not properly conducted. There is violation of principle of justice, natural justice. I'm on that. And that is what the judgment in the Autula and Song's case is. And subsequently, they have conducted an inquiry. And then after conclusion of the inquiry, they have removed the petitioner from service. Fine. If you want to conduct the inquiry, you do it in accordance with law. I'm only insisting on that. But you are imposing a penalty of a grave nature and you have not bothered to follow the procedure. That is not proper. So there is violation of principles of natural justice. So if you want to conduct the inquiry, proper inquiry should be conducted and we should be heard in person and full opportunity should be given so as to substantiate my stand.
You remind me of a small joke. What had happened was that earlier in the villages, there was a common well where all the ladies went and got water. So in one of such days, a lady came to the well and told the another lady that I went to your house for a cup of sugar. It was not there. So this lady says that, well, who told you it is not there? He said, your son's wife. He said, how can she say that? Come with me. And she took the lady to her own home, for winding lanes, about half an hour of walking. They reach home. And inside the home, the lady says that, okay, sugar is not there. So that's what your daughter-in-law said. Why you brought me here? Well, in my home, who is she to tell you no? I will be the person who will tell you no. So if it is fake, it is fake. You want a complete inquiry and then say that yes, it is fake.
That is to be proved. Since I am the authority, no, this is not right. And that should be final and binding. They have conducted the inquiry in such a manner.
Okay. Yes, if that be so, you proceed afresh with the inquiry.
Fresh inquiry.
If you did in the last
Yes,
case.
that can also be done, Your Lordship. However, Your Lordship, now that the university are here before this court.
Mr. Jimmy, you are also to submit for another petitioner?
Item number 7.
7 to 13. Just let him complete after Mr. Jimmy.
And I 7 to 13.
Yes.
I adopt the submission made by the learned counsel, Your Lordship. And in addition to what he has submitted, another point here, which Your Lordship may kindly take note of, is that the verification report The verification report, Your Lordship, the charge against me was proved. That verification report was not furnished to me, to the petitioner. And secondly, Your Lordship, no witness were examined to prove the documents, Your Lordship. Only based on documentary evidence without examining any witnesses, Your Lordship. That is not legally sustainable, Your Lordship. So the entire process stands vitiated. And it's in support, Your Lordship. I'll just place some case laws, Your Lordship.
Yes.
The first case, Your Lordship, it is AIR 1957, Supreme Court 882, Union of India versus T.R. Verma. This is by a constitutional bench, Your Lordship. I'll take, Your Lordship, the relevant paragraph only, and also the passage. Para 10.
Yes.
Para 10, Your Lordship. 8 line from bottom. Para 10. I have just highlighted the bit.
In this case, there would be some difference because of the fact that in
This
this case, there was an issue of taking and giving of bribe.
Yes, but 311, Your Lordship, natural justice. Stating it broadly, Your Lordship has got it. Just stating it broadly and without intending it to be exhaustive, it may be observed that rules of natural justice requires that a party should have the opportunity of adducing all relevant evidence on which he relies, that the evidence of the opponent should be taken in his presence, and he should be given the opportunity of cross-examine the witnesses examined by that party, and that no material should be relied on against him without his being given an opportunity of explaining them. Now, this is the case, Your Lordship. None from the university who has issued the verification reports were examined, Your Lordship. Now, the second case, Your Lordship, is 1998. Volume 8 SCC, page 582. The short paragraph 345.
Very well.
Para 3, 4, and 5. May I read out, Your Lordship? Short paragraph. Before us, the sole ground urged is as to the non-observance of the principle of natural justice in not examining the complainant's brandishing such and such and the witness such and such. The tribunal as well as the High Court have brushed aside the grievance made by the appellant that the non-examination of these two persons has prejudiced his case. Examination of these two witnesses would have revealed as to whether the complaint made by such and such was correct and not, and to establish that he is the best person to speak of its veracity. So also such and such who has accompanied the appellant to the hospital for medical examination would have been an important witness to prove the state of the condition of the appellant. We do not think the tribunal and the High Court were justified in taking that non-examination of these two persons would not be material. In these circumstances, we are of the view that the High Court and the tribunal erred in not attaching importance to this contention of the appellant. However, Sri Goel, the learned additional Advocate General State of UP, has submitted that there was other materials which was sufficient to come to the conclusion one way or the other, and he has taken us through the same. But while appreciating the evidence on record, the impact of the testimony of the complainant cannot be visualized. Similarly, the evidence of such and such would also bear upon the state of inebriation, if any, of the appellant. In the circumstances,
Mr. Javed, if I remember it correctly, this was a case where this delinquent, that is Hardavi Lal, the appellant before Supreme Court, he was in an inebriated condition.
yes, Your Lordship.
And he hurled abuses against the superiors.
Yes, Your Lordship.
And therefore, this man was taken by the people of the office for his medical checkup.
Yes.
So therefore, you see, this is something which is a deliberation on which this happened. But here in this, after this lift irrigation case, there are two things. Number one, what lift irrigation has laid down the law with regard to the degrees obtained by distance education. There is one. Second is that the UGC guidelines as well as the IGNOU documents, they all say that off-campus is not permissible.
But Lordship, I'm just trying to impress upon your Lordship the importance of for examination of witnesses, your Lordship. Now, I'll take your Lordship to my next case, your Lordship. That is Rup Singh's case, 2009. Here, it clearly stated that documents must be proved by examining witnesses, your Lordship. Paragraph 14.
Yes.
Paragraph 14, your Lordship. Indisputably, a departmental proceeding is a quasi-judicial proceeding. Paragraph 14. Lordship has got it?
Rup Singh Negi.
Yeah.
Oh, I'm sorry.
2009, volume 2.
Yes. Just a moment.
May I read your Lordship?
Yes.
Indisputably, a departmental proceeding is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during the investigation by the investigating officer against all the accused by itself cannot be treated to be evidence in the disciplinary proceeding. No witness was examined to prove the said documents, Your Worship. As per the principle laid down, Your Lordship, by the Honorable Appeal Court in Rup Singh Negi, Your Lordship, the documentary evidence is not sufficient. It must be proved by examining the witness, Your Lordship. Now, I have last case, Your Lordship. This is the latest one, 2023, volume 18, SCC 311. Para 8, 11, and 13, Your Lordship. 8 and 11.
Yes.
8, Your Lordship. A departmental proceeding against a delinquent is a serious matter as it has its repercussion, which can be far-reaching. It is tried law that the departmental proceedings are quasi-judicial proceedings. The inquiry officer functions in the quasi-judicial capacity. He has a neutral role to perform and cannot act as a representative of the management. He has to act as an independent and impartial officer to find out the truth. The major punishment awarded to an employee visits serious civil consequences, and as such, the departmental proceeding ought to be in conformity with the principle of natural justice. Even if an employee prefers not to participate in inquiry, the department has to establish the charges against the employee by deducing oral as well as documentary evidence. In cases charged warrant major punishment, then the oral evidence by producing the witnesses is necessary. producing witnesses necessary, Your Lordship. Para 11.
Nagar Panchayat, the notice was not served of the
Lordship.
proceedings to the delinquent.
Now,
In this case, you are citing President Nagar Panchayat Umari.
Lordship,
Their notice on the delinquent was never served of the proceedings.
but even here in the memorandum of article of charges, Your Lordship, in the list of witnesses which has been mentioned, Your Lordship, none from the university is there.
You've taken note of your submission.
Your Lordship must have taken note of it.
Yes, you said I noted it down.
Yes. Now, para 11, we have no hesitation in holding that in absence of the tax collector having been examined as a witness by leading evidence in support of his signature, whatever, Your Lordship. The inquiry officer arrived at unsubstantiated finding based on no materials but founded on unfounded suspicion, Your Lordship. 13, we are therefore constrained to hold that of finding recorded by the High Court that the departmental inquiry was not conducted in accordance merit no interference, Your Lordship. This is a case where Lordship finding was arrived at without examining the witnesses. So and that is my main ground, Your Lordship. And initially, Your Lordship, in the writ petition, we have not made the university a party because we are not agree. We are questioning the action of the state respondent, the manner in which the departmental inquiry was conducted, Your Lordship. But the matter was heard. But then at one point in time, and then this honorable court felt it necessary to implicate the university as party respondent. So accordingly, they were implicated. Otherwise, the petitioner is not seeking any relief as against the university who are implicated as respondent number 6 and 7, Your Lordship. So adopting the submission made by the Learned Senior Counsel, and in addition to that, whatever I've submitted, Your Lordship, taking into consideration the fact that the finding has been arrived at solely based on the verification report, which report was not furnished to me, to the petitioner, and also that fact was proved without examining the witness. So in that on that ground, Your Lordship, my submission is that the departmental inquiry stands vitiated, may be interfered with, and I have no objection if fresh inquiry is conducted. That's all, Your Lordship.
I was about to cite some rulings, but then that was left out. I will cite only 3 judgments. The first judgment will have about 5 paragraphs, and in the second judgment and third judgment, only 1 paragraph each. So the first
Just a moment.
judgment is 2010.
Just a moment. Yes.
2010 to ACC 772, paragraph 19, 29, 30, 34, 36 to 39. That is on the point of incriminating documents were not allowed to be refuted, witnesses not examined, full opportunity was not afforded, therefore violation of principles of natural justice. So
Please
may I
read the
read
paragraphs again
paragraph 19,
of this 2010
2010 to ACC,
paragraph.
paragraph 19,
Mhm.
29, 30, 34, 36 to 39.
Yes.
May I read paragraph 19? Upon due consideration of the extensive pleadings of the parties, the division bench has recorded the following conclusions. This is the finding of the division bench. After hearing the rebel submission of learned counsels for the parties, as well as the amendments made in the affidavit, we are of the view that the inquiry officer has not afforded opportunities to the petitioner insofar as he failed to supply the documents to the petitioner, which he has relied while framing the charges, and further, the petitioner was not afforded an opportunity to lead the evidence and also denied the opportunities of cross-examination of the person. The inquiry officer has also failed to prove the charges during the inquiry proceedings by recording any evidence. Thus, the inquiry is vitiated and is in violation of the principles of natural justice. With these observations, the writ petition has been allowed. The appellant has been directed to reinstate the respondents with all consequential benefits. However, the state was granted liberty to conduct fresh inquiry in accordance with law and the principles of natural justice. And then paragraph 29. Page 16.
Yes.
Apart from the above, by virtue of Article 311, Clause 2 of the Constitution of India, the departmental inquiry had to be conducted in accordance with the rules and natural justice. It is a basic requirement of the rules of natural justice that an employee be given a reasonable opportunity of being heard in any proceedings, which may culminate in punishment being imposed on the employee. 30. When a departmental inquiry is conducted against a government servant, it cannot be treated as a casual exercise. The inquiry proceedings also cannot be conducted with a closed mind. The inquiry officer has to be wholly unbiased. The rules of natural justice are required to be observed to ensure not only that justice is done, but is manifestly seen to be done. The object of rules of natural justice is to ensure that a government servant is treated fairly in proceedings, which may culminate in imposition of punishment, including dismissal, removal from service. We are removal from service. Paragraph 34. This court in Gashinath Dikshita versus Union of India has clearly stated the rationale for the rule requiring supply of copies of the documents sought to be relied upon by the authorities to prove the charges leveled against the government servant. In that case, the inquiry proceedings had been challenged on the ground that non-supply of the statements of the witnesses and copies of the documents had resulted in a breach of rules of natural justice. The appellant therein had requested for supply of the copies of the documents as well as the statements of the witnesses at the preliminary inquiry. The request made by the appellant was turned down by the disciplinary authority. And then paragraph 36. On an examination of the facts in that case, the submission on behalf of the authority that no prejudice had been caused to the appellant was rejected with the following observations. Be that as it may, even without going into the minute details, it is evident that the appellant was entitled to have an access to the documents and statements throughout the course of inquiry. He would have needed these documents and statements in order to cross-examine the 38 witnesses who were produced at the inquiry to establish the charges against him. So also, at the time of arguments, he would have needed the copies of the documents. So also, he would have needed the copies of the documents to enable him to effectively cross-examine the witnesses with reference to the contents of the documents. It is obvious that he could not have done so if copies had not been made available to him. Taking an overall view of the matter, we have no doubt in our mind that appellant has been denied a reasonable opportunity of exonerating himself. 37. We are of the considered opinion that the aforesaid observations are fully applicable in the facts and circumstances of this case. Non-disclosure of documents having a potential to cause prejudice to a government servant in the inquiry proceedings would clearly be denial of a reasonable opportunity to submit a plausible and effective rebuttal to the charges being inquired into against the government servant. 38. The proposition of law has been reiterated in Deoloknath versus Sunana India, this is very famous judgment, wherein it has been held that non-supply of the documents amounted to denial of reasonable opportunity. It was held as follows. Had he decided to do so, the documents would have been useful to the appellant for cross-examining the witnesses who disposed against him. Again, had the copies of the documents been furnished to the appellant, he might, after perusing them, would have exercised his right under the rule and asked for an oral inquiry to be held. Therefore, in our view, the failure of the inquiry officer to furnish the appellant with copies of the documents, such as the first information report and the statements recorded at the Shihipura house and during the investigation, must be held to have caused prejudice to the appellants in making his defense at the inquiry. 39. The proposition of law that a government employee facing a departmental inquiry is entitled to all the relevant statements, documents, and other materials to enable him to have a reasonable opportunity to defend himself in the departmental inquiry against the churches is too well established to need any further reiteration. Nevertheless, given the facts of this case, we may re-emphasize the law as stated by this court in the state of Punjab versus Pakatram, so and so. The state contended that the respondents was not entitled to get copies of statements. The reasoning of the state was that the respondent was given the opportunity to cross-examine the witnesses, and during the cross-examination, the respondent would have the opportunity of confronting the witnesses with the statements. It is contended that the synopsis was adequate to acquaint the respondent with the gist of the evidence. The meaning of a reasonable opportunity of showing cause against the action proposed to be taken is that the government servant is afforded a reasonable opportunity to defend himself against charges of which inquiry is held. The government servant should be given an opportunity to deny his guilt and establish his innocence. He can do so when he is told that the charges against him are. He can do so by cross-examining the witnesses produced against him. The object of supplying statement is that the government servant will be able to refer to the previous statements of the witnesses proposed to be examined against the government servants. Unless the statements are given to the government servant, he will not be able to have an effective and useful cross-examination. It is unjust and unfair to deny the government servant copies of statements of witnesses examined during investigation and produced at the inquiry in support of the charges leveled against the government servant. A synopsis does not satisfy the requirement of giving the government servant a reasonable opportunity of showing cause against the action proposed to be taken. So the state has committed serious lapses and there was violation of principle of justice. Therefore, this order was passed. The next judgment, only one paragraph, Lordship, 2017, 2 ACC 308. That is paragraph 7. We are it, Lordship. We have given our anxious consideration to the submission at the bar. It is true that the writ court is very slow in interfering with the findings of fact recorded by the departmental authority on the basis of evidence available on record. But it is equally true that in a case where the disciplinary authority records a finding that is unsupported by any evidence whatsoever, or a finding which no reasonable person could have arrived at, the writ court would be justified, if not duty bound, to examine the matter and grant relief in appropriate cases. The writ court will certainly interfere with the disciplinary inquiry or the resultant orders passed by the competent authority on that basis, if the inquiry itself was vitiated on account of violation of principles of natural justice, as is alleged to be the position in the present case. Our case is squarely covered by this. Non-application of mind by the inquiry officer or the disciplinary authority non-recording of reasons in support of the conclusion arrived at by them are the grounds on which the writ court are justified in interfering with the orders of punishment. The High Court has, in the case in hand, found all these infirmities. In the order passed by the disciplinary authority and the appellate authority, the respondent's case that the inquiry was conducted without giving a fair and reasonable opportunity for letting evidence in defense has not been effectively refuted by the appellant. More importantly, the disciplinary authority does not appear to have properly appreciated the evidence nor recorded reasons in support of his conclusions. To add insult to injury, the appellant authority, instead of recording its own reasons and independently appreciating the materials on record, simply reproduced the findings of the disciplinary authority. All told, the inquiry officer, the disciplinary authority, and the appellate authority have faltered in the discharge of their duties, resulting in miscarriage of justice. The High Court was, in that view, right in interfering with the orders passed by the disciplinary authority and the appellate authority. And I will switch over to the next judgment, which is the last judgment. 2021 is CC Online, Supreme Court 995.
This is, Mr. Jamil has also cited this. Same.
Yes. Yes, yes. So the law is very clear, and of course, I may have the liberty to reply, but then in the event of interfering with the immune orders and in the event of passing any direction for a fresh inquiry, then in that case, Lordship, the consequences would be, since we have been removed from service on the basis of an illegal order, then the period from the date of removal from service and till the culmination of the fresh inquiry, that period should be taken into consideration by this honorable court, Lordship, because we were removed from service without properly conducting the inquiry, Lordship. Obliged.
For your Lordship convenience, easy reference, I prepared a chart showing giving the details of the petition of the Lordship. So if you not your Lordships.
Again, in a lighter note, everybody tells me that this is a highly advanced state. So why we don't follow that US pattern of removal?
US pattern.
Because the president says go, one goes. No challenge.
No order, just no written order, only verbal.
Yes.
May I please, my lord? Lordship, now that my lord is already aware that the petitioners are removed from service on account of submission of a fake document. Now, your lordship, whether that was a fake document or not, the universities, various universities from where the petitioners have submitted their documents are here before this court. If they can first give the submission whether the documents was fake or not, your lordship, I'll be in a better position to take a stand, your lordship. So if the lordship may kindly allow them to make their submission first, my lord.
They will not say it is fake.
Yeah, your Lordship.
They will not say it is fake.
No, universities are here. They've already filed the affidavit. They already filed the affidavit.
No, but still, why will the petitioners come and say that?
No, your lordship, not the petitioner, but the council for the universities. Council for the various universities, they are here, my lord.
No, in fact, you see, with what Mr. Siti Jamir, Senior Counsel, Mr. TV Jamir has said,
Yes.
submitted.
Yes.
First of all, when it is a departmental proceeding,
Yes.
You will have to establish that it is fake. Merely because the universities come and admit it's a fake document.
Yes,
Still does not ratify the correctness of the manner in which the departmental proceeding was taken up.
Lordship, yes,
So let us assume for the time being that they say yes.
yes,
All the respondents, the universities say yes, it's a fake document.
yes.
But are you absolved from proceeding in a manner prescribed by law?
Lordship, then in that case, Your Lordship, allow me to make my submission then, my lord. Your Lordship, I am submitting from the first item, WPC 251,
Yes, yes.
Lordship. Your Lordship, the department
Sangam, you are listening, say you are senior committee.
Yes, my lord.
Yes.
Lordship. Now, Your Lordship, the department has undertaken a mainstreaming of the teachers. And while doing so, the documents, the certificates that the teachers have submitted to the department was sent to various universities from where the documents has been procured by the teachers for verifications. Your Lordship, the documents of the petitioners was relating to their diploma in elementary education, Your Lordship, was also sent to the university. That is, Your Lordship, in respect of the first rate petition, that is WPC 51. It is from the University of Mewar, Rajasthan, Your Lordship. Here, verifications was sought from this university whether the DIED, that is Diploma in Elementary Education certificate that was submitted by petitioner was genuine or not. Your Lordship. Now, Your Lordship, the university has written it back.
Where is the appointment order?
Your Lordship, the appointment order, Your Lordship will find it at page 21 of the read, Annexure C, my lord.
21.
Yes, my lord. Now, my lord, they,
Mrs. Amir, to both of you, this page 21 in this first writ petition is a temporary appointment. Was the appointment converted into a permanent appointment? Regularized.
And then, having DLA course, that is, as per the guidelines, that is, in the regularization on.
yes, it is as per the guideline. I see.
Initial appointment is on the basis of an advertisement and on the basis of a selection. So normally it is regular appointment, not temporary and ad hoc appointment.
It might be.
No,
Yes.
that's okay.
In
But
his case,
the initial appointment is still temporary.
even
Was
if
it-
the person is appointed on the basis of a selection by NPSC or any state selection board, in the appointment order, it will be shown as temporary. And they will be declared permanent after about 15 years, 20 years like that. It's not that, since in the appointment order, it is shown as temporary, it is a temporary appointment. No. My learned
Yes.
friend will agree on that.
Yes, Your Lordship. May I continue, my lord?
Yes.
Now, Your Lordship, as I was saying,
Yes.
The concerned university was asked to verify the certificate, that is the DIED certificate, and the university has sent a letter, a verification report to the department. Your Lordship will find that at page 11 of my affidavit in opposition. Page 11 of my affidavit in opposition, my Lord.
By 1, 2, and 3.
Yes.
Yes.
Now, Your Lordship, subject, this is a letter dated 27/7/2021. Subject, Your Lordship.
Yes.
Subject, verifications of N. Manon, this is the name of the petitioner, Your Lordship, and Lokna Konyak, course DEIED. This is Diploma in Elementary Education, my Lord. Respected sir, with reference to a letter numbered such and such dated 18 May 2021 regarding verifications of N. Manon and Lokna Konyak, after matching with university records, the documents are not issued by the Miwa University. And the same I attach with their letters for further necessary actions at your end. So the university stated that it is not being issued by them. And for which, Your Lordship, the show cause notice was issued. Lordship will find the show cause notice on page 28, annexure G of the writ petition, Your Lordship. Page 28, Your Lordship.
Just a moment.
Yes.
Page 20.
28, my Lord.
Repeat.
Of the writ petition, my Lord. The type copy, Your Lordship, is at page 29. Allow me to read from the type copy, Your Lordship.
Yes.
To Sri N. Manund, PT GPS Mont, subject Shokas. The Lordship, the first para it starts with, whereas a prima facie case of gross misconduct against you has been established in submitting fact document in elementary education DIED certificate purportedly issued by the Miwa University, Rajasthan. And whereas there is a reasonable ground to believe that you have been utilized fact documents and misled the department for availing undue service benefit. And whereas the offenses committed by you are of grave and serious nature, which views very seriously as they are in direct violations of Rule 41 of the Nagaland Government Servant Conduct Rules 1968. Now, therefore, you are hereby directed to show us in writing within 10 days from the date of receipt of this notice as to why disciplinary proceedings should not be initiated against you for the violations of the Nagaland.
Just a moment.
Lordship.
Nagaland Government Servants Conduct Rules, 1968. You have beautifully kept it. Very good.
May I continue, my Lord?
Yes.
Now, Your Lordship, the show cause notice itself is very clear why the show cause has been served. It was for the reasons that the petitioner have submitted a fact DIED certificate, Your Lordship. Now, Your Lordship, as per the show cause notice, they were given a 10 days time to give their reply. the petitioner gave the reply, which your lordship will find it on the next page, that is page 30.
Yes,
Your lordship, to save time, allow me to read only the relevant paragraph, your lordship. I wanted to point something here, my lord.
yes,
Reply to the Principal Director, Directorate of School Educations, Kohima, subject, reply to the show cause notice number such and such dated 17th of February 2022. Allow me to read the second paragraph that starts with that, sir. May I read this, my lord? That, sir, I hereby submit my statement in connection to the show cause notice issued by a higher authority. That, sir, as professional qualifications is required for better quality education for the children in good faith, I enrolled myself in distance education mode in Mewar University of Rajasthan, having learned from reliable source that the Mewar University is a recognized open university, which also offered the course for DIET. As such, without any bad intention and with my layman views, I took up the course. I also do not have any bad intention to violate the Nagaland Government Service Rules 1968. Here, your lordship, categorically, the petitioner is stating that I have enrolled myself in the university. I just wanted to point out that, your lordship. Then thereafter, your lordship, memorandum was issued, articles of charges was framed. Your lordship will find it at page 31. I may be allowed to read only the relevant para, your lordship. Para 1. This is memorandum dated 2nd of March 2022, my lord.
yes,
Para 1, your lordship. The undersigned proposed to hold an inquiry against Srimati and Manund, Nagaland, under Rule 9.2 of the Nagaland Discipline Appeals Rules 1967. The substance of imputations of misconduct or misbehavior in respect of which the inquiry is proposed to be held is set out in the enclosed statement of articles of charges, Article 1, Annexure 1, a statement of imputations of misconduct or behavior in support of each article of charges is enclosed. Now, your lordship, the article of charges, your lordship will find it on page 32.
yes,
Article Annexure 1, statement of articles of charges frames against Srimati and Manund PT. Article 1, that the said Sri and Manund, while functioning as PT, violates Rule 4, Section 1, Subsection 1 and 3 of the Nagaland Government Conduct Rules 1968. Annexure 2, statement of imputations of misconduct or behavior in support of the articles of charges framed against Srimati and Manon PT. Article 1, that the said Sri and Manon, while functioning as PT, submitted fake diploma in elementary education's DIED certificate purportedly issued by the Mewar University, Rajasthan, has utilized the fake document to mislead the department for availing undue service benefit, thereby fail to maintain absolute integrity and indulge in act unbecoming of a government servant. Annexure 3, list of the documents by which articles of charges framed against Srimati and Manon PT are proposed to be sustained. 1. Letter from the competent authority of the Mewar University, Rajasthan, certifying that the diploma in elementary DIED certificate submitted by Srimati and Manon is fact, not genuine. Annexure 4, list of witnesses by which articles of charges framed against Srimati and Manon PT are proposed to be sustained. The headmaster, GPS Puka Mond. Now, your lordship, while issuing this memorandum and framing the article of charges, your lordship, the petitioner was also asked to submit a written statement in her defense within a period of 10 days from the date of the receipt of this memorandum, Your Lordship. That is mentioned in para 2 of the memorandum dated 2nd of March 2022. Within 10 days, Your Lordship. The petitioner submitted a written statement in defense, Your Lordship, which Your Lordship will find at page 33. Page 33, my lord. May I read this, my lord? To the Principal Director, Director of School Education, Nagaland, Kohima, subject, submission of written statement in response to your memorandum number such and such dated 2nd of March 2022. Respected sir, with immense pleasure and humble prayer, I write to your memorandum number such and such dated 2nd of March 2022 for your kind favor and necessary action, please. I also hereby submit my written statement as per the direction of your proposal of articles of charges framed against me, which has been marked as annexure. I also intend to submit my written statement in the form of annexure. 1, Your Lordship. I do hereby state that I do not have any ill motive towards the government and misled the department. I acted in good faith. However, I apologize if my humble deeds has been found to be violating any of the rules laid down by the government of Nagaland. I also hereby state that I have been sincerely rendering my service as a government servant since I was appointed as a primary teacher through competitive exams and serving till date. Your Lordship, again, the next line is important. I enroll myself through distant modes private to meet the requirement of the department complying to the department notifications to complete the training course on the before March 2019. As such, in good faith, I produced a document from the Miwa University of Rajasthan, having learned that non-compliance of the department notifications may hamper my service, which as a result, I may be terminated. Again, he's saying she has enrolled herself, Your Lordship. Annexure 2. Annexure 2, Your Lordship, the type copy is at page 35. I may be allowed to read from this page.
Yes.
Annexure 2, I do hereby state that I enrolled in a Mewar University, Rajasthan, having learned that the DEIED course has been offered through distance mode from the reliable sources. After which, I also Googled and found that Mewar University is a recognized open university. Therefore, in good faith, I enrolled myself through distance mode with an intention to complete the course within the stipulated period of 2019, after which I submitted in the year 2021. I also admit that I was misguided and misinformed by someone else to submit the said document. Therefore, sir, I hereby state that since I submitted only in the year 2021, I have not availed any undue service benefit from the department. Hence, pray that I may be given opportunity to obtain relevant training as required by the department. Then in Annexure 3, Your Lordship, he is submitting his admit card and mark sheet. Categorical statement, Your Lordship, that she has been enrolled in the university. After that, Your Lordship, an inquiry committee was constituted and an inquiry notice was issued, Your Lordship, to the petitioner. Lordship, kindly allow me to take my Lordship to page 36. Page 36, my lord.
Yes.
This is the inquiry notice dated 21 March 2022, my lord. Kindly allow me to read this, my lord.
Yes.
Whereas An inquiry under Rule 9.2 of the Nagaland Discipline and Abuse Rules 1967 is being held against Srimati N. Manon, PT, GPS Puka. And whereas a board of inquiry has been constituted to inquire into the charge frames against him or her under Rule 9.4 of the said rules. Now, therefore, Srimati N. Manon are hereby directed, 1. To present himself, herself for hearing before the Board of Inquiry on 30th March 2022 at 10 a.m. at room number 411, Directorate of School Education, Kohima, Nagaland, along with all documents, record, materials in pertaining to the pursuit of the DEIED course. B. Intimate the name of defense assistance if he or she intends to engage one. C. Inspect within 5 days documents, a list of which has been sent to him or her with the charges. D. Submit a list of witnesses to be examined on his or her behalf with their address indicating what issues they will help in clarifying. And E. Submit list of additional documents he or she wishes to have access to, indicating the relevance of the document to the presentation of his or her case. So she was allowed to appear before the inquiry board in person. The documents which she to inspect the documents within 5 days, and also to submit a list of witnesses if she desire. Your Lordship. As stated in the inquiry notice that directing the petitioner to appear before the board on 30th of March 2022, she appeared before the board. And the inquiry committee has submitted its report. Your Lordship will find that at page 38. Page 38, my lord.
Yes. In this page, you will find one query of us.
Lordship.
In respect of this page, you will have a query from us.
Lordship.
Read it, then we'll put that query.
Lordship.
Or you want us our query first?
No, I would like to read it first, my lord. Inquiry report, Your Lordship. Introduction. An inquiry under Rule 9.2 of the Nagaland Discipline Appeal Rules 1967 is being held against Srimati N. Manan, PT GPS Puka, via memorandum dated 2nd of March 2022. A board of inquiry was constituted with Srimati Grace Ashom, Deputy Director, Directorate of School Education as chairperson, and Sri B. Nalaya Yapant, Assistant Director, DOSC, and Srimati Talilula, the Assistant Director, DOC, as member to inquire into the charges framed against him under Rule 9.4 of the said rules via order number dated such and such, order number dated 14th March 2022. Your Lordship, the next para. The Board of Inquiry summoned the charged government servant to present himself for a hearing before it on 30 of March 2022 at 10 a.m. at the Directorate of School Education, Kohima, Nagaland. The statement of the charged government servant was recorded and all materials document related to the case was summoned and examined. Your Lordship. 2. Defense assistance availed by the charged government servant and his participation in the inquiry. The charged government servant did not avail services of defense assistance during the inquiry proceedings. 3. The article of charges on statement of the imputations of misconduct and behavior. Article 1. That the said Srimati N. Manon, while functioning as PT, violated Rule 4, Section 1, Subsection 1 and 3 of the Nagaland Government Servant Conduct Rules 1968, and statement of imputation of misconduct or behavior, Article 1, that says Srimati N. Manon, while functioning as PT, has submitted fact in elementary education certificate purportedly issued by Mewar University, Rajasthan, has utilized the fact document to mislead the department for availing undue service benefit, thereby failed to maintain absolute integrity and indulge in act of becoming of government servant. Case of the disciplinary authority, Your Lordship. The charged government submitted has the statement of defense wherein she denied the articles of charges. Then the next is the case of the charge of government servant, assessment of evidence, Your Lordship.
Yes, you want
No.
us to ask questions? No.
Now, Your Lordship, from all these documents, it shows that the petitioner was very much a part of that proceedings. It is not that in any of the proceedings, the petitioners was not allowed to participate in the proceedings.
No,
She
in
was-
fact, this is something I would love. You see, I am here to preside the court.
Lordship,
You all are here participating in the process.
Lordship,
Now, what happens if I don't hear you?
yes,
You all participate in the process.
yes.
You're all here. I put questions here and there, and I don't allow you to complete. That statement I made and you replied that whether you want our questions first or your submission first.
Lordship.
We take offense of your reply and then we proceed arbitrarily. If that is okay with you, I'm glad.
No, your Lordship, your Lordship may put up my Lord Goris, Your Lordship.
Now you see in this page 38 you were reading,
Yes, my Lord.
third paragraph,
Yes, my Lord.
the Board of Inquiry summoned the charge officer to present himself for a hearing.
Yes.
Now, where is the statement in this inquiry report that somebody from the government was heard, examined?
Yes, Your Lordship.
It's
No,
not
of
there.
course, it is not here.
Now you, perhaps you would be aware, it created a lot of anxiety to many people. I authored a judgment, some Debnath, as Debnath. It was by the division bench, and the bench was criticized both by the government and by the appellants. A lot of furor. It was in the media for quite a long time. You've seen that judgment, no?
Your Lordship,
I'll check. It is otherwise in the principal seat, it is known as APSC scam.
Lordship.
That the judgment is Kamal Debnath. I was a part of the bench sitting in the division bench, and we set aside the judgment of the Learned Single Judge in the case of Gitali Dole, on the ground that the principles of natural justice were not followed. In that case, also,
Lordship.
the proviso Article 300, Article 311, so clause 2 was not followed. The government did not reserve the right to terminate without the employee was a temporary employee, and he was terminated without reservation of right under Article 311 to not to proceed against the persons. That was approved of by the Learned Single Judge on the ground that the ground on which the Learned Single Judge interfered with the accepted the termination was that all these appointees were appointed after some sort of bribe to the APSC. And therefore, the chairman of the APSC was apprehended. The investigation of the police revealed that he had taken illegal gratification. And therefore, the court says that without that, he would not have entered into service and therefore termination. In your case, it's the same logic. Had this fake document not been there, he would not have entered into service. But
Yes.
the right was not reserved under Article 311(2). So therefore, is it available to you not to follow the procedure prescribed under the Nagaland
Disciplinary principles, Lordship.
So if not, if that reservation is not there for the state, then it has to go back. There's no alternative. And incidentally, although the judgment was criticized a lot, no appeal was filed. Till now, I am not following that judgment, but till now, because we have a system here where any order of ours is appealed against before the Supreme Court of India, we get an intimation. So there is a system created so that we don't make the same mistakes on which the Supreme Court has interfered with the order. So therefore, since I have not received any communication of an appeal being preferred or entertained by the Supreme Court of India, I'm not aware of it.
Lordship.
Mr. Chaudhary behind would have known about it. Any information of any appeal? No. It's a very long judgment
Lordship.
that you subscribe to Supreme today,
Yes, Your Lordship.
then you will find it there. Just search it in your mobile.
Lordship.
Kamal Debnath. KAMALDEBNATH.
Lordship.
Because most of the the issue is only that whether this departmental proceeding could have been dispensed with.
Lordship, one more issue is there. If my lord is having a
Take a break and come
yeah,
back.
yes.
Yes.
So may I continue, my lord?
Yes.
So, Your Lordship, basing on the inquiry report, the impugned order terminating the petitioner arose, Your Lordship. Now, Your Lordship, as my lord has been putting up a query, as well as my two learned senior friends, has categorically making a submission on the issue of violations of principle of natural justice, Your Lordship.
Yes.
Now, Your Lordship, my two senior friends has been saying that the documents which should have been furnished to them has not been furnished, which violates the principle of natural justice. They're also making a submission that the verification report has not been submitted to them, or no witnesses to prove that the documents was genuine or fact, was examined.
Yes.
Your Lordship, though these queries is being set forth, Your Lordship, they have not explained anything in the writ petition as to how it has prejudiced them.
That's not required.
As to how it has prejudiced them, for the fact that, Your Lordship, the documents is their documents. They submitted it. It is not that we produce it. It is your own document. They were a part of the disciplinary proceedings, Your Lordship. Show cause was served. Memorandum, the article of charges was framed. They were given a chance to reply.
Has any authority decided that point?
Yes, Your Lordship.
That their document need not be served?
No, Your Lordship. How are they prejudiced?
No, that's what I'm asking.
Yes. On the issue of that prejudice.
Has any constitutional court in the country
Yes.
held in favor of that proposition?
Yes, Your Lordship. Yes. I may be allowed to place it at the end of my submission, Your Lordship.
Okay.
So until unless it is shown that they have been prejudiced, Your Lordship, they cannot come and say that, no, this has been violated, or the principle of natural justice has been violated, my Lord.
Yes.
The second point that I wanted to make, Your Lordship, is the petitioner I hear before this court claiming that it is not because the documents are fake, but the documents which they have submitted is from an unrecognized university. I would like to take my Lordship to page 9, para 17 of the writ petition. Page 9, para 17, Your Lordship.
Yes.
I may be allowed to read this, my lord. That the petitioner begged to state that the allegations of fake document is misconceived, as the document obtained through unrecognized university cannot be termed as fake certificate, and as such, the petitioners was removed from service on baseless ground for which the interference of this High Court is called for. So they want this Honorable Court to interfere on the impugned orders on the ground that they were not removed for submission of a fax document, but for submission of a document which is from the unrecognized institute, my lord. Para 18, Your Lordship, I may be allowed to read this also. The petitioner begged to state that the pursuing DEIED course from an unrecognized university was an unintentional mistake committed on the part of the petitioner, as she got herself admitted to the said university without the knowledge that the university was not recognized by the Department of School Education, Nagaland, Kohima. Therefore, removing the petitioner from the service for a fault which cannot be attributable to the petitioner is arbitrary and discriminatory. So they are here before this court stating that they have been removed, not because of submission of a fake document, but because they submitted the document from an unrecognized university. which is a misleading statement, Your Lordship. It is a misleading statement. I will place my citations on this as well, Your Lordship. Now, Your Lordship. Against the Lordship, against the inquiry report, they have filed their appeal, Your Lordship.
Incidentally, you know what has happened.
Lordship,
Come to your affidavit,
yes, my affidavit, my lord.
page 5 and 6.
Yes.
You're there at page 5.
Yes, my lord.
You have replied to paragraph 11, 13, and 17 in paragraph 9.
Yes.
Next page is turned, you are replying to paragraph 19.
Yes.
Incidentally, paragraph 18, you have not responded.
Lordship, Your Lordship, I have mentioned paragraph 18 on the page, para 7 at page 4, my lord.
Paragraph 7.
Statement made in paragraph 10 and 18, my lord.
Okay.
I have also categorically take a stand in my affidavit that, Your Lordship, the petitioners are not removed from service on account of submissions of a certificate from an unrecognized university, but because of fact, submissions of a fact document, Your Lordship. I have taken that stand, my lord.
Okay. So I made a mistake here.
Lordship?
I made a mistake here.
Oh, no, not at all, not at all, man. Not at all. So, Your Lordship, the petitioner has filed their appeal against this inquiry report. Lordship will find that at page 41
Of the writ petition?
of the writ petition, my lord. Sorry, man. An extra M.
Page 41.
Page 41, my lord.
Yes, this is reply.
Yes, this is the reply they gave, Your Lordship.
Hmm.
Nowhere they have taken a stand that they were not produced with the document. They were not asked to examine the witnesses. Nothing. They were not aggrieved at all, Your Lordship.
This shows that they were not in able hands then.
That can be said, Your Lordship. But no, Your Lordship, they have not projected any of such grievances. Now only they are projecting. Appellate authority also, Your Lordship, before the appellate authority also, they have made an appeal. But again, Your Lordship,
This is what happens when you are in good company.
even in the appeal made before the appellate authority, Your Lordship, they have not mentioned anything as such. That all these things, no opportunity was given to them. Even in the writ petition, they are not saying how are they prejudiced by all this. They are just saying that the rules has not been followed. Yes, but how are they prejudiced by that, my lord? And therefore, Your Lordship, on 2 counts, I wanted to make my submission, Your Lordship. First, the petitioner has tried to mislead this court. by making a categorical submission in the writ petition that they were removed on account of submission of a document from an unrecognized university. That's the first thing. Second thing, Your Lordship, the petitioner nowhere in the writ petition has been able to show or project that they were prejudiced, if at all, by the action of the disciplinary authorities. Number three, Your Lordship, once a disciplinary authorities take a decision, what are the judgment that has been said, whether the High Court can interfere with the decision given by the disciplinary authorities, Your Lordship? I would like to place my citation on these three counts, Your Lordship. First, on the principle of natural justice, Your Lordship, 2006-7 SCC, (599).
Please give it again.
2006, 7th SCC, 560, Your Lordship. The relevant para, Your Lordship, will find it at 560.
What is it? Name of the parties? Okay, book is there. Sheetal Manoj Gaur.
Yes. Para 9, Your Lordship. Para 9. I may be allowed to read this para 9, my lord.
Yes.
By now, it is well settled principle of law that the doctrines of principle of natural justice are not embodied rules. They cannot be applied in a straitjacket formula. To sustain the complaint of the violations of principle of natural justice, one must establish that he has been prejudiced by non-observance of the principle of natural justice. As held by the High Court, the appellant has not been able to show us as to how he has been prejudiced by non-furnishing of a copy of the inquiry report. The appellant has filed a detailed appeal before the appellate authority, which was dismissed as noticed above. It is not his case that he has been deprived of making effective appeals for non-furnishing of the copy of the inquiry report. He has participated in the inquiry proceedings without any demur. It is undisputed.
You're reading paragraph?
9, my lord.
9, no, there's something mismatch. Paragraph 9 in the SCC starts from the second submission. If it is SCC online,
Yes, Your Lordship.
oh, then it may not match.
Your Lordship. Lordship, yes, parent, I will read it and then I will place the citation before my lord.
Hmm.
Yes, I'll be referring to para 9, and the starting word is by now. It is well settled, Your Lordship. Anyway, this is on the principle of natural justice, my lord. I may be allowed to place this.
Okay, you please proceed. Please read it again.
Lordship.
By now.
By now, it is well settled principle of law that the doctrines of principle of natural justice are not embodied rules. They cannot be applied in a straitjacket formula. To sustain the complaint of violations of principle of natural justice, one must establish that he has been prejudiced by non-observance of the principles of natural justice, as held by the High Court. The appellant has not been able to show as to how he has been prejudiced by non-furnishing of a copy of the inquiry report. The appellant has filed a detailed appeal before the appellate authority, which was dismissed as noticed above. It is not his case that he has been deprived of making effective appeal for non-furnishing of copy of inquiry report. He has participated in the inquiry proceedings without any demur.
No, something is wrong.
Yes, Your Lordship.
Ask me that.
I have marked.
No, it's a totally different case,
Lordship.
not this one. 2006-7, SCC 558. No. something wrong. Even the SCC is making mistakes now.
Lordship, I will place it that it is SSC online.
No, we are giving you both the books.
Yes.
The SCC online citation is different,
Yes.
and this 588, this citation is different. Because this Sheetal Manoj Gore
Yes.
is a case of preventive detention.
Yes, yes, Your Lordship, here,
Yeah.
yes.
Now, same thing. Whether this citation is fake.
No, I got it from SSC online, my lord.
No. I just keep my mood lighter. Nothing.
Now I'm in a dilemma whether to place it or not, my lord.
No, you see, Mr. Jamil, this is very strange. This is not the first case I have found in SCC. When
Correct.
they are referring to SCC online and SCC, this book, there is a difference, always a difference.
In paragraph, obviously.
So the same person is publishing two different citations, cases. Just see this. Show it to Mr. T.P. Jamil. It's very strange.
Lords, if I may submit, in the case of Vijay Madalal also, the citation of SCC online was working.
Your Lordship,
for-
page number is different.
Page number is.
Page number is different here.
Okay, please come in again. I did not hear you.
In the case of Vijay Madalal also, my lord,
Ah.
the SCC online citation was working for 3 years. And now since it was published, all the paragraph
All the
from it,
same.
everything was changed. So
Yeah.
the
No, my
SCC
lordship is here. It's here.
published judgment is different from the online judgment, my lords.
It's here also.
Okay.
The page was, yes, the page number is different, my lord. Para 9, my lord. Para 9, on the top, your lordship. On the left-hand side, my lord. Para 9. It is,
Okay.
yes, your lordship.
Om Prakash Man.
Yes.
Citation is wrong.
Yes. I'm safe now, my lord.
This becomes 558. 558.
Yes, your lordship, 5. Here, in the SSC online, it's page 560.
Yes.
No. Seven SSC, this is 12 SSC.
Yes.
Yes. Your lordship, the next citation I would like to place before my lord is 2008 7 SEC 584, para 13, my lord. The jurisdiction of the High Court is mentioned in this para, your lordship. If I may be allowed to read this.
Para?
Para 13, my lord.
Yes.
Under the circumstances, your lordship. Under the circumstances.
Yes.
Under the circumstances, the question arises whether the division bench of the High Court was justified in setting aside the order of removal of the respondent from service and remitting the matter to the appellate authority, namely the Inspector General of Police, to consider the question of imposition of appropriate punishment short of removal from service, commensurate with the gravity of the proven misconduct of the respondent.
No, again, there is something wrong. What is the name of your case?
Lordship, the name of the case is State of Meghalaya and other versus Mekan Singh M.N. Marag.
No, again, this is wrong. This is DLF Universal.
No, Lordship, I have.
State of Meghalaya.
Yes.
Oh no, this citation here is 580.
Yeah, 580. I'm reading from para 13, which is at 584, my lord. I'll be referring para 13, 14, and 15, my lord.
Yes.
Para 14, my lord. May I read it, my lord?
Yes.
In the matter of imposition of sentence, have my lord got it? In the matter of imposition of sentence, the scope of interference is very limited and restricted to exceptional cases. The jurisdiction of the High Court to interfere with the quantum of punishment is limited and cannot be exercised without sufficient reasons. The High Court, although has jurisdiction in appropriate cases to consider the question in regards to the quantum of punishment, but it has a limited role to play. It is now well settled that the High Court, in exercise of the power under Article 226, do not interfere with the quantum of punishment unless there exists sufficient reason therefore. The punishment imposed by the disciplinary authorities or the appellate authority, unless shocking to the conscience of the court, cannot be subjected to judicial review. In the impugned order of the High Court, no reason whatsoever has been indicated as to why the punishment was considered disproportionate. Failure to give reasons amounts to denial of justice. The mere statement that it is disproportionate would not suffice. Para 15. While considering the questions of proportionality of sentence imposed on a delinquent at the conclusions of departmental inquiry, the court should also take into consideration the mental setup of the delinquent, the type of duty to be performed by him, and similar relevant circumstances which go to the decision-making process. If the charged employees hold the position of trust, where honesty and integrity are inbuilt requirement of functioning, it would not be proper to deal with the matter leniently. Misconduct in such cases has to be dealt with an iron hand. Here, misconduct is committed by a teacher.
It doesn't help you, this case.
No, Your Lordship, I'm just showing as to how whether the disciplinary authorities, when they take a decision, whether it can be revoked or removed. I'm just trying to show that, my lord.
But on facts, it doesn't help you.
Here, the only difference is, Your Lordship.
No. Here, this is different. You know this case?
Yes.
Here, he was a police constable.
Yes.
And he was asked to disburse some amount. He did not disburse the entire amount, and he was asked to report back to the headquarters. And instead, he went to Shillong in a night super bus. And there he slept, and his revolver was snatched away. He was stolen.
Yes.
And after that, in the disciplinary proceeding, many witnesses were examined. And after that, the disciplinary authority gave a finding which was concurred by the appellate authority, and then the High Court interfered with the punishment. Then it says it can't.
Yes,
That's a well-settled law.
Yeah.
Not only this Mekan Marak, but there are many cases where it has
yes,
said
yes,
High Court should not substitute,
yes,
because High Court under 226 is only exercising jurisdiction which is akin to certiorari.
correct,
So therefore, in such cases, there are limitations to the power of the court.
correct,
It's not an appellate authority.
correct.
So that is the principle which is laid
Yes.
down much prior to this.
Yes, I'm just showing the principles on your lordship. Your lordship, as with regards to the fact submission of fact document, allow me to refer to a citation 2022-17 SEC. 2022-17 SEC. Page 368. 368 start para 22 in the present case. Two 2022, your lordship, 17 SEC 361. I'm referring to para 22, my lord. Para 22 and 29, my lord. Only two paragraphs.
Paragraph?
22 and 29, my lord.
Yes.
It starts with in the present case, my lord.
Hmm.
In the present case, the original writ petitioners was dismissed from service by the disciplinary authority by producing the fabricated fact forged SSLC. Producing the false fact certificate is a grave misconduct. The question is one of a trust. How can an employee who has produced a fact and forged mark sheet or certificate, that too at the initial stage of appointment, be trusted by the employer? Whether such a certificate was material or not, or had any bearing on the employment or not, is immaterial. The question is not of having an intention or mens rea. The question is producing the fact or forged certificate. Therefore, in our view, the disciplinary authority was justified in imposing the punishment of dismissal from service. Para 29, my lord.
Yes.
Para 29, my lord. I may be allowed to read this, my lord. In any case, in the facts and circumstances of the case, and for the reasons stated above, and considering the charge and misconduct of producing the fact and false SSLC certificate proved when a conscious decision was taken by the disciplinary authority to dismiss him from service, the same could not have been interfered with by the High Court in exercise of power under Article 226 of the Constitutions of India. The High Court has exceeded in jurisdiction in interfering with the order of punishment imposed by the disciplinary authority while exercising its power under Article 226 of the Constitutions of India, Your Lordship.
No, this is also same.
Same.
Like earlier.
Yes, yes.
Here,
So,
here also,
yes, when it is proved,
here it was proved.
yes.
So in your case, that exercise was not done.
Your Lordship, here, it is being proved. It has been proved beyond any reasonable doubt because the university itself has filed an affidavit saying that, no, we have never. And even before the disciplinary committee starts, Your Lordship, the university has sent a letter to us stating that they have never issued these.
That's right. If affidavits are so sacrosanct, then I would have disposed of more cases sitting at home than coming to court.
Yes, my lord.
I would have done more better, I can tell you.
Then on the issue of, Your Lordship,
If this, because in this case also, you see the charge sheet was submitted and the evidence was led. And thereafter, in the criminal court also, this respondent he was held guilty and he was punished. And in this case, there is another point in this Indian Oil Corporation case. You'll find it at paragraph 10 of the order. No, sorry, 9 of the order. Paragraph 9 of this.
Lordship.
Here, although he produced a fake certificate, but educational qualification was not even a criteria. My earlier statement that I am a commerce graduate and I claim to be a engineering degree holder, because here to be in the profession, the requirement is that you must have LLB and a degree of any degree
Yes.
and LLB. So degree, whether it is commerce or engineering, doesn't make a difference.
Lordship. Lordship.
Here also, you see paragraph 9, it says that it is not even required, but still he gave that. And
Yes.
therefore, misconduct, there was a disciplinary proceeding, there was finding of guilt, and then in the writ petition, the ground taken was, since I have admitted the guilt, please give me lenient punishment.
Yes.
And therefore, the High Court interfered. So that says can't be permissible, because when the disciplinary authority comes at a finding,
Yes.
it can't be done.
Yes. Now, Your Lordship, on the issue of misrepresentation that I have stated, Your Lordship, allow me to place a citation on this, Your Lordship. 2008-12 SSC 481. I'll be relying on paragraph 34, 36, 38, and 39, my lord.
K.D. Sharma.
Correct, my lord. K.D. Sharma.
Yes.
Para 34, Your Lordship. It starts with the jurisdiction. If my lord is there with me on that para, allow me to read it, my lord.
Yes.
The jurisdiction of the Supreme Court under Article 32 and the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hand, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merit of the claim. Para 36, Your Lordship.
Yes.
A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court will certainly bear in mind the conduct of the party who invoked the jurisdiction of the court. If the applicants make a false statement or suppresses material facts or attempt to mislead the court may dismiss the action on that ground alone and may refuse to enter into the merit of the case by stating, "We will not listen to your applications because of what you have done." The rule has been evolved in a larger public interest to deter unscrupulous litigants from abusing the process of court by deceiving it. Para 38, my lord.
Yes.
The above principle has been accepted in our legal system also. As procedural law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of the High Court under Article 226 of the Constitution is supposed to be truthful, frank, and open. He must disclose all material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or to pick, choose, or to pick and choose the facts that he likes to disclose and to suppress or not to disclose other facts. The very basis of the writ jurisdiction rests in disclosure of true and complete facts. If the material facts are suppressed or distorted, the very functioning of the writ court and exercised would become impossible. The petitioner must disclose all the facts having a bearing on the relief sought without any qualifications. This is because the court knows the laws but not the fact. 39. If the primary objects as highlighted in Kingston Income Tax Commissioner is kept in mind, and an applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hand, suppression or concealment of material facts is not advocacy. It is jugglary, manipulation, maneuvering, or misrepresentation, which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts and truly but states them in distorted manners and mislead the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule nisi and refuse to proceed further with the examination of the case on merits. If the court does not reject the petition on that ground, the court will be failing its duty. In fact, such an applicant requires to be dealt with for contempt of court for abusing the process of the court. Para 51, my lord.
Yes.
Yet in another case, in Vijay CL versus State of Punjab, this court stated, in order to sustain and maintain the sanctity and solemnity of the proceedings of law court, it is necessary that parties should not make false or knowingly inaccurate statement or misrepresentations or should not conceal material facts with design to gain some advantage or benefit at the hand of the court. When a court is considered as a place where truth and justice are solemn pursuits, if any party attempts to pollute such a place by adopting recourse to make misrepresentations and is concealing material facts, it does so at its risk and cost. Such party must be ready to take consequences that follow an account of its own making. At times, lenient or liberal or generous treatment by court in dealing with such matter is either mistaken or lightly taken instead of learning a proper lesson. Hence, there is a compelling need to take serious views in such matters to ensure expected purity and grace in the administration of justice, Your Lordship. So on account of misrepresentation of facts itself, Your Lordship, this case, all these writ petitions deserve to be dismissed without even entering into the merit of the case, my lord. That will be my submission, my lord. I am deeply obliged.
The council was there, the university. Yes, in the meantime, anything in reply?
In WBC 251 of 22 and 252 of 22 for the Mewar University.
You're from?
Mewar University.
Mewar University. In WBC number?
251 and 252, both of 2022.
Your name, please?
Tongpang. Mewar University.
Yes, your name?
Tongpang.
How do you spell it?
TONGPANG.
Yes. Yes.
Your Honor, we have filed our affidavit in opposition. And we have categorically stated in our reply, para number 8, and a reply to para number 7 of the writ petition. I may be allowed to read out that as regard the statement made in para number 7 of the writ petition, claiming the writ petitioner to have perused diploma in elementary education, 2 years course from Mewar University, Kankra District, Chittorgarh, Rajasthan, and have qualified in the year 2008. The deponent outrightly denies the correctness of the said statement and beg to state that the name of the writ petitioner has never been enrolled in the Mewar University, nor the writ petitioner studied in the university at any point of time. Therefore, the question of the writ petitioner appearing in any examination conducted by Mewar University does not arise. The deponent also respectfully begs to state that at no point of time the Mewar University introduced or recognized any distant education system, nor allowed any other institution outside the state of Rajasthan to affiliate with the Mewar University. Hence, the deponent respectfully begs to state and submit that the marks cum grade report, mark annexure X, to the writ petition purported to have been issued by the Mewar University is false and flatly denies the genuineness and correctness of this document. And Your Honor, as stated in their affidavit in reply also in their para number 4, they have they are now saying that it is the Isaac Newton's school, which I may be read out, allowed to read out para number 4 from the middle part of the para number 4 in their reply. Further, it was only during the time of inquiry by the department, the petitioner came to know that the Isaac Newton School was not genuine, and the petitioner became a victim of a fraudulent act. So, Your Honor, regarding the claim that the Mewar University is an unrecognized university, Your Honor, regarding that, I would like to rely on our affidavit in opposition in WPC 252 para number 12. The deponent further begs to state and submits that the Mewar University was established under the Mewar University Chittorgarh Act 2009, Act 4 of 2009, and Act of the State Legislature of the Rajasthan, and received the assent of the governor on the 3rd February 2009. And the university has no operations and jurisdiction outside the state of Rajasthan. So, Your Honor, the petitioners claim that the Mewar University is an unrecognized university is totally misconceived. And regarding the marks cum grade report claiming to be issued by the Mewar University, we flatly deny that it has been issued by us, by the Mewar University at any point of time. Your Honor, at this point, my humble prayer will be that since now it is an admitted fact that the marks cum grade report and the admit card were never issued by the university, and as impliedly admitted in their reply, the issue regarding remanding back or to hurt the petitioner will serve no fruitful purpose, since the main issue remains is that the mark cum grade certificate itself is not genuine. It's a fake document. Much obliged.
Please, my lords.
Yes, you are appearing for?
Lords, I appear for respondent number 8 and 9 and item numbers 7 to 13. I appear for Janardhan Nagar University, Udaipur, my lords.
Your name?
Lord Sakshat Bhardwaj.
Voice is being distorted. Please come again.
Lord Sakshat Bhardwaj.
You are appearing for which university?
Janardhan Nagar University, my lords. Janardhan Nagar Vidyapeeth University.
What is the name? Which university?
My lords, Janardhan
Janardhan University.
Rai Nagar
Nagar Vidyapeeth.
Vidyapeeth. Rajasthan.
Janardhan Rai
Nagar
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 Vidyapeeth, Rajasthan.
Udaipur.
Vidyapit. Okay.
Please, my lords.
Yes.
My lords, our submission are in two folds, my lords. First is regarding the misjoinder of parties, my lords. My lords, we were being asked by the Directorate of Education about the specific position of 7 students, in our reply to which on a letter dated 23 July 2019, we have specifically told that the students for which the information is sought does not belongs to our university, neither they ever availed any admission in our university, my lords. My lords, secondly, the documents which are annexed in respect of the university, which are supposedly issued by the university, we have completely denied the fact that those were issued by the universities, as those does not even bears the seal and signature of the either the chairman or the vice chancellor or the any of the trustees of the university, my lords. My lords, thirdly, the averment that the said university is a fake one was never raised in our respect, my lords. The university is recognized by the UGC, my lords, and we'll keep our argument very crisp and short, my lords, that the only role which was assigned to us was that the documents which are annexed with this petition were said to be given by us, my lords. But as per our records, my lords, no such documents were ever issued. Neither the students which are in question, my lords, were ever a part of our curriculum, my lords. They had never taken any admission in our course, neither at in our course at our university, my lords, please. I'll keep my arguments to this much, my lords. Rest I'll adopt the arguments as the reply is stated.
Okay.
Also, I'm representing the Nagaland University in item number 4, 5, 6, and 11, Lordship.
Just take their presence in all the read petitions because otherwise I'll make a mistake. Huh? Whoever are there in other matters, or all
5, 6, 11.
take a memo. Huh? I'll request all of you to give your names in the memo because otherwise I'll make a mistake in the referring to the lawyers in the matters. Yes, your name,
Moa Jamil, Lordship.
Moa Jamil. Yes.
Also, I'm representing the Nagaland University, Lordship. Lordship, our role is very limited in this case, Lordship. The Department of School Education, they have written to the university on 15 March 2021, Lordship. We were asked to verify 948 documents, certificates of B.Ed qualification, Lordship. Now, on verification, we have also submitted the verification report, Lordship, district-wise. I have enclosed the district, the relevant district as far as the petitioners are concerned.
948 documents.
948 documents. Wherein the present petitioners are also included, Lordship. If I may
Yes.
be allowed to refer to the report which was submitted, Lordship, I'll just show the name of the petitioners only. Just
It's
4
okay.
pages, Lordship.
Once you say that, we accept it.
Yes, Lordship. Now we have verified, and it is the finding of the university is that they were never enrolled. No doubt, Lordship, the college from where the petitioners obtained a certificate is an affiliated college under the Nagaland University, Lordship, but on verification, their names were never enrolled. That is the limited finding, Lordship, and we have submitted a report to the department, Lordship, for further necessary action, Lordship.
Yes.
We have submitted a report in the affidavit, which I have filed in all the 4 petitions, Lordship. That is my limited submission, Lordship.
So there's one query for you, Sangami. The other writ petition, copy of the order which was shown by
Yes.
Mr. Siri Jamir,
Yes.
in respect of those petitioners, they are also part of the same employment.
Yes, my lord.
Asongla Pongena.
Yes.
Same.
Same. As the London Senior Council has stated that the difference here, Your Lordship, the difference here was in that case, by deciding the case, Your Lordship, the university concern was not implemented, and therefore they did not come forward as to whether the document was, or not. So that was not, it was not there. Yes, of course, Your Lordship, the concerned university has sent a letter stating that the document is fact. That is the first difference in this matter. Second thing is, Your Lordship, in the inquiry report, instead of the name of the petitioner, that is Ausengla Pongana, the name of the present petitioner in the WPC 114, that is the second writ petition, was mentioned. Typographical error.
Where is that finding?
Finding, Your Lordship will find it at page para 24. Para 24, Your Lordship. From the last 3 line, it starts with dust, Your Lordship.
Yes.
Dust, it appears in the report, a report that the name of Srimati Alila Imsong was mentioned instead of the present petitioner, Srimati Ausengla Ponganer, as regard the person who has submitted the fact death certificate. This Alila Imsong, Your Lordship, is the petitioner in the WPC 114 of 2020, which is the item number 2, my lord. So since in the inquiry report itself, Your Lordship, the name of the petitioner was wrong, and inquiry could not have been held against the petitioner, which is in violation of principle of natural justice. This is what this Honorable Court has a finding, Your Lordship, and we agree with it.
Okay. You want to give a reply?
A short reply, Lord,
Okay.
after the break.
May I please, Your Lordship? May I
Yes.
please, Your Lordship? Your Lordship, my sincere apologies for intervening at the middle of the proceeding. However, if I may be allowed to make a mention on item
Mention
number.
not now, because you're all rising, that's why. At 2 o'clock, do it.
May it please your lordship.
Yes.
Lordship, I may be allowed to mention hearing item 26, lordship. We have for the respondent number 4. Lordship may be gracious if this matter be listed in a short period, lordship. I have a consensus prayer if this
Tomorrow?
matter. Tomorrow there's a DB, lordship.
Day after tomorrow?
Lordship, if this can be on Monday, 15,
You are saying short.
lordship.
Okay. What says the representative of the prayer made by Learned Council for respondent number
4, lordship.
4? List on Monday would be 15.
15, lordship.
Lordship, interim may be extended. Lord. There's an interim, Lordship.
Interim order passed today stands extended till the next date of this thing.
Much blessed.
Please, Your Lordship. Lordship, if I may be allowed to make a mention of item number 29, my lord. And for the petitioner here, my lord. Lordship, if this matter can come up next week, my lord, on Thursday, 18, my lord. I have taken the consent, my lord.
Okay. But if I allow, I'll be unemployed. You want that?
My lordship, actually, my senior was ready to come up, but we were under the impression that this matter might
Oh, don't have
take
impression.
some time, my lord.
Impressions are,
This, my lord, my apologies.
impressions are deceiving. There's a very old song when we were young. We used to sing that. This song is very good. दिल को देखो, चेहरा ना देखो, चेहरे ने लाखों को लुटा. So it's a very old song. Remember it. No impressions in court.
Lordship, I.
Okay, 29. Okay, next week.
Lordship, next week on 18, my lord. Thursday.
Okay, 18th.
Complex fine.
Yes.
Please, your lordship. My lord, maximum focus and emphasis was made by all the councils, including the Council for the State, has made submission and focus more on the fake certificate. That is why almost all the respondents, they have made submission on that only. By amalgamating all the points submitted by the respondents, I would just like to reply by a one-line response that yes, there may be, may not be. That is one side of the story from the respondents. I should have been allowed to narrate my own story. That was denied. Had ample opportunity been afforded, I would not have been before this honorable court. But then having failed to do so, I am before this honorable court, lordship. And I was not allowed to refute the allegations, not allowed to cross-examine, and by relying on the submission of the respondents, if any finding is to be arrived by this honorable court by analyzing whether it is genuine or not genuine, focus or not focus, I believe that will not be the role of this honorable court. That will be in the course of the inquiry, they can prove also. Therefore, the inquiry, I have been prejudiced. That is one point, solely on the certificates. So it is a common reply to all the respondents in that regard. And coming to the submission of Mr. Enangami, the counsel representing the state, by referring to the inquiry proceedings, he has shown and referred the reply because we were asked to submit written statement.
Where is that written statement?
He has already referred to, and no, not in the form of a written statement.
No, you said yes or no. Where is that?
Reply. 33. Reply was given by referring to the reply written statement.
But this is not yes or no.
33.
But this is not yes or no.
Yes. No. Yes or no was during the personal hearing of during the inquiry.
Where is that?
Where is
that?
I do not have that, but then I made categorical statement that a format was furnished to us, and then you have to tick yes or no.
Okay. Is the records available?
I will come on that point also. I do not know whether my learned friend is having that. So what I was trying to,
Lordship, I'm informed that Enangame, he is in VCs and some matter questions.
what I'm trying to project before Lordship is, by referring to the written statement which was filed by the petitioner, my learned friend was making a submission that ample opportunity has been afforded. In order to support that, he was referring to this written statement that
No, that
in no way,
that we have noted, but we were
Yes.
anxious to know your.
in no way we are deprived. That is what he was trying to say, but Lordship is well aware. Mere filing up the W is not enough in a trial. In a trial, Lordship is well aware what are the procedures to be followed. Therefore, this itself is not sufficient enough to say that ample opportunity has been afforded to the petitioner. That is what I am trying to apprise your Lordship. The third point, which my learned friend has tried to apprise the Honorable Court, was page 38. The inquiry report. I will refer to the paragraph 3. Here, the presence of my learned friend will be very much required. Paragraph 3. The Board of Inquiry summoned a charge common servant to present himself for a hearing before it on 30th March 2022 at 10 a.m. at the Directorate of School Education, Kohima, Nagaland. The statement of the charge government servant was recorded. I'm relying on this, was recorded, and all material documents related to the case were summoned and examined.
Mr. Hanabi, you have the departmental records?
No, Your Lordship.
See, why I'm referring to this, by relying on this, ample opportunity has been afforded to the petitioners. That is what my learned friend has submitted. Now, show from record. What are the statements I have given? What are the records they have examined and produced so as to examine and contest? Show from record. And if there is no record, then is it not misleading? My learned friend has also used the word misleading and misrepresentation. Let them show from record. Just in order to defeat the case of the petitioner, in the inquiry report, they have mentioned this. If you are saying something that, okay, on that particular day, I have done like that, like that, like that, you show from record. It's not the job and work of an individual. It is the statement given by an authority about the conduct of an inquiry and the records maintained by the office. Let them show from record. From day one, my contention was very clear. During the inquiry, a stereotype questionnaire was prepared and we were furnished to fill up that. Can that be treated as a proper inquiry? And in the other case, that is Ausana's case, which I have referred to your lordship, this honorable court has clearly arrived to a finding on all this. Therefore, if at all the statements were recorded, show from record, and materials documents were shown, not that by way of filing the affidavit in opposition, they are bringing and saying this. So this should be enough. No, during the inquiry, I'm talking about the inquiry, whether those documents were furnished and whether we were afforded any opportunity to cross-examine and to refute on these allegations. And if it is not shown from the records by the government, a department who is running an office, they should have the record. Mere saying will not do. So let them support from record, and if they cannot show from record, it will amount to misleading statements they have made so as to defeat the case of the petition. If lordship is clear on that, I would like to switch over to the next point which my learned friend has submitted. My learned friend was making a submission that there is no statement in the writ petition how the prejudice was caused. Therefore, we are misstating this honorable court. That is the submission my learned friend has made. Now, keeping that in mind, who is misleading the court, let us see. Kindly come to paragraph 22 of the writ petition. Whether I have made that particular statement or not. Because nowhere in the petition we have mentioned that we were prejudiced. And how we were prejudiced, that is not stated in the petition. That is what my learned friend has submitted. Probably my learned friend may not have read this paragraph. Has your lordship got it? That the petitioner begs to state that the Board of Inquiry has arrived to a finding to remove her from service without properly appreciating the facts and law which has caused prejudice to the petitioner. Law and facts.
No, you see what
So-
has happened. You in your pleading come to paragraph 19 of your plaint, the writ petition.
Yes.
In paragraph 19, you say that the board inquiry denied her the opportunity to be heard in person. Correct. Now in the reply, the government, the state respondents say that you have been given an opportunity. Now in your reply, now you have said in page 3 of your reply, the said condition was not complied with by the respondent authority. She was never allowed to appear before the Board of Inquiry on the date to defend her case. So this was not your original case. After the reply, this is an improvement.
The statement which I have made in paragraph 19.
In 19, you don't say that you are never allowed to place your case before the board. No, not to appear before the Board of Inquiry. Here in paragraph 19, you say Petitioner is to say Board of Inquiry denied opportunity to be heard in person and examine the evidence of so and so, and was asked only to answer so and so. That means
Lordship,
this will happen only when you appear before the board.
this difference, here there is a gray area. The questionnaire which we have answered, the token that we were summoned and appeared before the Board of Inquiry. By responding to the questionnaires, they meant to say that this petitioner has been summoned, appeared, and stated whatever she
This
was.
is what you say. This is para 19 is your statement.
Yes. My lord, W is the difference, the slight difference will be the WS has been prepared by the petitioner concerned by a ordinary person. And the statement in paragraph 19 is the statement made by a counsel. That makes the difference. But the fact remains that they are treating this answering the questionnaire as hearing the petitioner in person. But whether ample opportunity was afforded or not, that is the question. In that, by referring to Ausanla's case, which is before your lordship, my learned friend has made a submission that there is a typographical error. It is a typographical error. That is what my learned friend has said by referring to paragraph 24 of the judgment. However, entering two different names which do not have any resemblance cannot be treated as a typographical error. Typographical error. It is an apparent non-application of mine. Instead of Mr. A, Z was brought and treated as A. So that shows absolute non-application of mine. And by doing that, the career of a person has been demolished. The last point which I wish to reply is, my learned friend has cited so many rulings on different points, but I find it not relevant considering the facts and circumstances of our case. The rulings which my learned friend has referred to has relevance in some other context, not in this, because ours is the compliance of the due process of law, which has not been followed. So we are questioning the due process of law, and that has not been followed.
Okay.
Therefore, Lordship, the rulings which my learned friend has cited are not relevant, taking into consideration of the entire facts and circumstances of our case. So with that, I conclude, Lordship. Highly obliged, Lord.
Lordship, I'll take 5 minutes, Lordship, short reply, in addition to what the senior counsel will say.
Yes.
Now, main grievance of the petitioner, Your Lordship, is that the verification report relied on by the inquiry officer at the time of the permanent inquiry was not furnished to me. And Your Lordship, the finding against me has been arrived at without examining the authority who has issued the verification certificate as a witness. That is my grievance, Your Lordship. Now, main grievance. Now, respective counsel from the university, they have also filed the university has filed an affidavit, which has been relied on. And in the affidavit, they have not stated that they were examined as a witness. And my case is that the authority who has issued the verification certificate, they were not examined as a witness, Your Lordship. Now, on the prejudice cost, the learned senior counsel senior government advocate, relied on three authority, Your Worship. Or 2006, SEC 558, that prejudice, the cause has to be shown, Your Worship. To counter that, let me just. This is 2010, Volume 2, SEC 772, Para 36. Paragraph 36, Your Worship.
Yes.
Lordship. On an examination of the facts in that case, the submission on behalf of the authority, that is the state respondent here, Your Worship, that no prejudice has been caused to the appellant was rejected with the following observation. Be that as it may, even without going into minute detail, it is evident that the appellant was entitled to have an access to the documents and statements throughout the course of the inquiry. He would have needed these documents and statements in order to cross-examine the witnesses who were produced at the inquiry to establish the charges against him. So also at the time of argument, he would have needed the copies of the documents. So also he would have needed the copies of the document to enable him to effectively cross-examine the witnesses with reference to the content of the documents. It is obvious that he could not have done so if copies had not been made available to him. Taking an overview of the matter, we have no doubt in our mind that the appellant had been denied a reasonable opportunity of exonerating himself, Your Lordship. The question of causing prejudice does not arise, Your Lordship. This is 2010, Your Lordship. Now, on judicial review, the senior government advocate, Your Lordship, has relied on two authority, 2008 7 SEC and 2022 17 SEC, page 368, Your Lordship. And in both the cases, Your Lordship, the matter relates to the quantum of punishment, Your Lordship, the quantum, where the High Court has interfered. And by exercising the power of judicial review, the Honorable Appeals Court has set a limitation of judicial review. That's all. Here, I'm not questioning the quantum, Your Lordship. I'm questioning the manner in which the inquiry was conducted against me. And then there is a violation of natural justice because the documents were not furnished to me, witnesses were not examined. That is my case, Your Lordship. And when it comes to violation of natural justice, Your Lordship, the power of judicial review, that cannot be questioned. Much obliged, Your Lordship. That's all.
Say. That's why. As common facts arise in all these cases, comma, all the matters were analogously listed and argued by the learned senior counsel or the counsel for the appearing parties. Accordingly, with the consent of all sides, comma, the matter was analogously heard. Next paragraph. Heard also the parties. Next paragraph. By filing these writ petitions under Article 226 of the Constitution of India, comma, all the petitioners You're appointed as what? Primary teachers and graduate teachers.
Yes. I will show that much. One minute.
All are primary teachers or you're graduate teachers also?
No, in my case, in real petition 263, as graduate teacher, I have given the details of worship center and the rest as primary teacher. The chart we have.
This chart?
Yes, real petition, I have given real petition to. So 263, I have given a bold bottom as graduate teacher, otherwise the other.
Okay. All the teachers were appointed. All the petitioners in WPC 259 of 2022, 260 of 2022, 261 of 2022, 262 of 2022, 264 of 2022, 265 of 2022
Yes, that is the situation.
were appointed as primary teachers.
Like, I think in other.
I will come one by one, Lordship. Item one.
No, don't give me my item number.
251,
Don't give me item number, give me the case number.
251 of 2022. Primary teacher.
Give the primary teachers first.
Yes.
Only give the numbers of primary teachers, 251,
Yes.
then,
I'll make a chart and then finish, Lordship.
okay. The chart, so-and-so, and so-and-so are graduate teachers. And whose services were terminated pursuant to the inquiry conducted and passing of the order dated 8/6/2022, as well as removal order dated 8/6/2022. I have prayed for quashing of the inquiry report dated 7/4/2022.
If I get up to page 5 of my the chart, page 5, column 15. I am also challenging the order passed by that another 3.
Okay.
Column 15.
Okay. Order dated 8/6/2022, passed by the Principal Director, Directorate of School Education, thereby ordering removal from service followed by another order dated 8/6/2022 regarding removal from service, as well as the appellate order dated 12/8/2022, thereby dismissing the appeal filed by the petitioners. Next paragraph. In brief,
Yes. Well, I'm to page 5 of the sheet. There is the order, actual order, but the order is order in the space of repetition 262. But in other repetition, the order part where that notification is 29 and 2.
okay.
In all I have given. Page 5. Page 5. Column 15.
Okay. Or 29.
29 and
29/9/22, sir. As well as 12/9/2022, past 2022. in WBC 263 or 2022, this one, last one. The order of 12 line is in WBC 263 or 2022?
No.
Okay. In brief, about the case of the petitioners is that pursuant to an employment advertisement which was published on 9/12/2011 by the Directorate of School Education, Government of Nagaland, for filling up the posts of primary teachers and graduate teachers, the petitioners applied for appointment to the said posts. Upon clearing the examination conducted by the authorities, the petitioners had joined in various schools. In support of their educational qualification, amongst others, the petitioners had submitted their degree of the diploma in elementary education. All are degrees or all are diplomas?
In case of primary teacher, he had that diploma in elementary education, but in case of graduate teacher, it is BA.
So the petitioners who had applied for primary teachers had provided diploma in elementary education from various private universities, and the petitioners who were appointed as graduate teachers had submitted their degree in elementary education from the private universities. Full stop. While in service, all the petitioners were issued show cause notice inter alia, stating that they had submitted fake degree of a diploma in elementary education, and they were directed to show cause within 10 days. As to why disciplinary proceedings should not be initiated against them for violation of Nagaland Government Servants Conduct Rules, 1968. Full stop. The petitioners submitted their show cause reply subsequently. All the petitioners were served with a memorandum dated 2/3/2022, accompanied with the statement of articles of charges, statement of imputations of misconduct, list of documents and the list of witnesses by whom the articles of charges framed against the petitioners was proposed to be sustained. Next, the grievance of the petitioners is that though they had filed their written statement and appeared before the Board of Inquiry in person on the date fixed, but the petitioners were not given an opportunity of being heard by the Board of Inquiry, and instead, they were supplied with a statement by the Board of Inquiry, and they were required to answer to put their answers in the questionnaire which was supplied to the petitioners. Full stop. Accordingly, comma, it is expressed by the petitioners that there was violation of principles of natural justice, and they were condemned without being heard by the Board of Inquiry. Full stop. It is further projected that in an appeal preferred by the petitioners, comma, no, the petitioners preferred an appeal, comma, which was however dismissed. And accordingly, this petition. Next, leading the submissions, comma, the Mr. C.T. Jamil and Senior Counsel, as well as Mr. T.V. Jamil and Counsel for the petitioners, have both submitted that that in course of inquiry, the verification report regarding their fake degree of the diploma were not furnished to the petitioners, and moreover, the Board of Inquiry had not examined any witnesses to prove any document. Moreover, comma, it is submitted that the petitioners were denied any opportunity of cross-examining any witness, as no witness were examined, and no opportunity was granted by the Board of Inquiry to the petitioners to give their evidence in defense. Full stop. In support of their submissions, comma, the Learned Senior Counsel and Learned Counsel for the petitioners have cited the following cases. This is the believer cap. Both Mr. C.T. Jamil and Mr. T.V. Jamil, can I kindly ask your assisting counsels to give a list with the with the paragraph numbers so that it can be incorporated. Give me this back. Next paragraph. For contra, the learned senior government advocate had submitted that the degree as well as diploma in elementary education, as submitted by the petitioners, were sent for verification. Thereafter, on and upon verification, when it came to their notice that the degree and or diploma as submitted by the petitioners were fake, the petitioners were served with a show cause notice dated 17/2/2022, which was followed by a reply submitted by the petitioners wherein all the petitioners asserted that they were enrolled in their respective universities. Full stop. Thereafter, memorandum of charges was served on the petitioners, but submitted their written statement. And thereafter, the petitioners was heard with inquiry notice under Rule 9 within bracket 2 of the Nagaland Services within bracket Discipline and Appeal bracket close rules, 1967, directing the petitioners to be present before the Board of Inquiry on the date mentioned against the notice to the petitioners, to the individual petitioners, and to appear before the Board of Inquiry with all relevant documents pertaining to pursuing of the degree / diploma in elementary education course, to intimate the name of the defense counsel if intended to be engaged, to inspect the documents, as per list which was sent to them, to submit the list of witnesses and the issues addressed by those witnesses, and to submit a list of documents. Full stop. Thereafter, the inquiry report was furnished to the petitioners and by a forwarding memorandum dated 8/4/2022, the petitioners were put to notice to make representation before the inquiring authority within a period of 15 days. And accordingly, the petitioners have submitted their reply to the memorandum dated 8/4/2022. Also, thereafter, the imperial order dated 8/6/2022 was passed by holding the petitioners to be guilty of willful violation of Rule 4, Section 1, bracket close, Section 1 within bracket, subsection small Roman 1 and 3 of the Nagaland Government Servants Conduct Rules, 1968, and a penalty or removal from service was passed by providing that the same shall not be a disqualification for future employment. Further providing that the order imposing penalty was being issued separately. And accordingly, a separate order dated 8/6/2022 was passed for removal from service. Next one, the learned senior government advocate had submitted that that none of the petitioners had submitted and suffered any prejudice as the fake degree public diploma by their own document so moreover, it is submitted that in paragraph 17 of the writ petition, the stand of the petitioners is that the degree was from unrecognized university and therefore those cannot be termed as fake. Accordingly, it is submitted that the petitioners have taken misleading stand in the writ petition, for which the writ petition was liable to be dismissed in limine. First of all, moreover, it is submitted that there being no pleading of prejudice and the disciplinary order was not liable to be lightly interfered with, as the degree of the diploma held by the petitioners were all found to be fake. First of it is further submitted that the degrees of the diplomas that were obtained by the petitioners are fake is supplemented by the stand of the respective universities who have filed a response denying that the degrees of the diploma were issued by them. First of all, in support of their submissions, of his submissions, the following cases were cited. You also please give a list, Sangam, with the paragraph numbers. Next paragraph. Mr. S. Bhardwaj appearing for learned counsel appearing for Janardhan Ryan Nagar Vidyapit and Mr. M. Javed, learned counsel for the Nagaland University, have both submitted that the petitioners were not the students of the private universities, and the authorities of the said universities, private universities, have denied issuing such certificates, and that it is also submitted that the Education Directorate of School Education had provided 948 documents to the Nagaland University for verification. And on verification, it was found that none of the petitioners were enrolled in the colleges as projected by the petitioners. And accordingly, a report was submitted by the Nagaland University to the Directorate of School Education. This one on facts, have I made a mistake? Anything to be added?
I do not know whether Lordship, I have clarified on the petitioners. Item one, WPC 251 of 2022, that is primary teacher. And item three, WPC 252
Just-
of 2022,
Just say slowly, let him write it down.
that is primary teacher. Otherwise, rest up to item number 6 are graduate teachers.
Okay, 1 and 2 are primary teachers.
No, 1 and 3
1 and 3
are primary teacher, right? 251 of 2022, 252 of 2022 are primary teachers.
Okay.
Rest are graduate teachers.
Okay.
Up to item number 6.
Item number 6. Okay.
And so far as certificates are concerned, item number 1 and 2, that is 251 of 2022 and 114 of 2022 are D-Lit, and rest from item number 3 to 6 are P8. That is the effects. D-Lit, Diploma
Diploma
in Elementary Education.
Achha.
Diploma in elementary education for primary.
Yes.
Diploma in elementary education.
And the graduates are P8.
B.Ed. Okay. Okay. I've just dictated facts in your presence so that I may not
Yes. That is most
uh, make a mistake. If I can complete the dictation by today, then tomorrow we'll release it. If I can't do it, then I'll pass an order to make it as CAV.
Lordship.
So
Lordship.
no, it was a very healthy debate. I enjoyed it. Is there any matter left in the board? I'll have to adjourn it today. Today I have a video conference. The matter will be adjourned because I have a video conferencing with the Legal Aid Council.
Your Lordship, in item 25, Your Lordship, I have an interim order till today, Your Lordship.
Okay,
In item 25,
25.
last occasion, I was
Positive time.
directed to, take justice step. I have also filed an affidavit of service, Your Lordship, yesterday.
Just give it.
Yes, item 25. Yesterday, I filed, I don't know whether so service upon response number 4, 5, and 6. Affidavit.
Okay. Mr. T.V. Jamil, counsel for the petitioner, has submitted that yes, that the petitioners have taken steps for service of notice on the respondent numbers 4, 5, and 6 by way of Dasti.
But none
Sure.
appears today.
Which were duly served on the said respondents. Along with copies of the petition. Now, how do you know who has received it? In page 5, it is received by Chang Beno Ungoi. Who is he? I don't know.
No. Your Lordship, at the bottom, the signature is there, and I was asked to, since I am not, the details of the response number 5 and 6 were not there, I was given liberty to take steps
We
through
understand, but you see, this page 5 is a notice to CEO.
CO. His
CEO
response
of
number,
Municipal Council, correct?
his response
But
number.
somebody who is receiving it must put the seal of the municipal council. That is not there because now we don't know who is this.
Only the
Thank
name,
Beno.
yes, seal is not there. Otherwise, he is the CEO.
He is the CEO.
He is the CEO. The name is there. Tung Jambini Tungyu.
No, because personally I do not know. That's why
Okay.
we'll rely on you.
Then your Lordship, it's okay. I can take fresh steps, Lordship.
No. You please show us that this is the person who's the CEO because.
See, here, your Lordship, page number 5.
Is there any other document in the writ petition saying that he is the CEO where his name appears?
Your Lordship may kindly come to page 20, writ petition. This is the order issued by the CEO, which I have impugned, your Lordship.
27.
Page 22, writ petition.
22.
Page 22. 22, writ petition.
Yes.
Thunjambini Tungyo, Chief Executive Officer.
Thungchan Bemo.
Yes. And signature is there. If your Lordship may tell you the signature also. The seal is not there, only signature, yes. Sir.
Okay. And second one?
The second one is the private respondent to whom that allotment was made. So I was asked to take steps through CO. So CO has served a copy and given me this receipt. 5 and 6. Respondent 5 and 6.
Page 6 and 7, you have jumbled up.
No.
Come to page 6. Come to page 6.
6.
It was addressed to Nilo I.
Oh, your Lordship, here what CO has done, your Lordship, in page number 7, the signatures ought to have been in page number 6.
Okay.
That is the.
That's okay.
That is the.
Okay. So showing due service of notice on response numbers 4, 5, and 6. And accordingly, notice is deemed to be duly served. So none appears for the said respondents. For enjoined justice, the matter stands adjourned today.
29.
List again after a week. Most of the interim order passed release stands extended till the next date of the state.
Interim order shall continue, your Lordship. Obligation.
Yes.
Lordship, I have one more item. Item number 20. Lordship, here I am yet to receive an instruction.
We will adjourn it otherwise also because I am.
Okay. Then we may allow to adjourn with the court master.
Okay, 20.
20.
Okay. Both sides are represented. I'm sorry, I forgot the names.
In team, so I'm for the state respondent, additional AG.
Okay. The name I am sorry, I just forgot.
I am so. In short.
Then additional advocate general for the state. I'm sorry, I've come after a long time. I missed out.
Definitely.
I'm sorry. Normally, additional AG name I shouldn't forget, but I'm sorry. This submits that he has not yet received instructions. So accordingly, matter stands adjourned today. List after 2 weeks.
2 weeks.
3 weeks. Any interim order is operating?
No, Lordship.
No,
There's no interim, Lordship.
Authors, I have one more matter, 22, item number 22.
22.
Yes. Here also is regarding the 2-lane construction work, but we have not yet received any instruction.
Same order.
I'm representing 2 and 3.
2 and 3. Was away. Okay.
This Lordship, I beg to mention
Just
item
tell the
number
court master,
one.
I have a meeting right now at 3. Just tell the court master, they'll do the. I'm addressing the legal aid council today.